show you shit you never seen. The 7 wonders of the world. And I can make you the 8 if you wanna be my girl. I say my girl, I don't mean my woman, that ain't my style. Need a real street stalker, walk a green mile, piling up the paper on the dining room table. Cause you able to realize I'm the truth and not a fable. Baby, rockin' Russian sable, keep that chiller on the rack. What I look like with some $1,000 shit up on my back. I'm $1 million man that need $1 billion bitch. Put my pimpin' in your life, watch your daddy get rich. Easy as ABC, simple as 1, 2, 3. Get down with UGK, Pimp CBU with B. Cause what's a hoe with no pimp, and what's a pimp with no hoe? Don't be a lame, you know the game and how it goes. We try to get toes.
A pimp, not a simp. A pimp, not a simp. A pimp, not a simp. We eat so many shrimp. I got iodine poisoning.
Hello, hello, hello. 1, 2, 3, 4, 5. I thought it was literally working while the stream was getting ready. What the hell? Anyway, let's start. Let's start over again. Hi everybody. It is Artie of Artie's Corporate Fiction. Happy Tuesday to all of you. The first thing I want to say today is wish my brother Alex a happy birthday. He turns the ripe old age of 38. And as we all know, he will not be getting most of the gifts. Everybody will just be giving gifts to my niece, because that's usually what happens, right? I don't know. I wouldn't know anything about that. Either way, I did give my brother something though, so don't, it's all good. So, happy birthday to him. Also, happy VE Day, victory in Europe. We finally, got the Kaiser to surrender, or is that the? I'm sorry, I'm getting my history wrong. Not that that was the Franco-Prussian War, not the. Yeah. Anyway, today we're going to be talking about a judge who is no longer in office. So, spoiler alert. Who, just like the super mayor of Dalton, Illinois, made a name for herself in not the best way. She had she's been alleged to do a lot of different things. We're going to take a look at the amended formal charges. This is actually the third formal charges. Some of the charges against her were dropped. I believe there was originally 52 charges alleged against her by the Judicial Qualifications Committee in the state of Georgia. That was some of them. They were then dropped to 30. She was I don't know if I don't want to say convicted, but she was found to have done a number of the charges, not all of them, but a number of the charges. And I'm kind of debating with myself, like, how do I want to introduce this to you guys? If you don't know who she is, because I feel like if I show you guys the local news reports about her, it'll poison the mind. The reason I say that is because they live streamed the entire hearing. How many days was it? 1, 2, all 6 days worth of hearings on YouTube. Now, we're not going to see everything because we'd be here all day, all night, and for the next several days. So I'm not doing that. But I do want to go to at least two different parts. One, the opening, so it'll at least give you guys a breakdown of what's being alleged. And two, a certain eyewitness testimony. So at the very least, we're going to go through those things. So that's behind the screen is the chart is the hearing, and this is the amended charges filed July 15, 2022. Now I want to go through this real quick. So I don't want to go like with all the silence when I'm going through the reading. So hold on a second here. Oh wait, wrong thing. Hold on a second. There we go. All right. So I don't want to go into this, but the first bit of facts to go against her is she is alleged to be using her position to try and further a budding acting career, right? But also a lot of the allegations stem from some of her conduct from her Instagram account. So, yeah. Let me see here. The one I wanted to look at here is, yeah, okay. So, so she has both an official Instagram account in her capacity as a judge, but she also has a personal account, I believe. The problem is that for her birthday, apparently on her birthday, she posted a birthday Cash App post on her official Instagram account. Now, she kind of feigns ignorance about this, but I don't know. I mean, I didn't even know that. I didn't even know that that's like a thing to do. Like, hey guy, like just post on Facebook. Hey, it's my birthday. Here's my Cash App. Just give me money. To, like, people I don't know. Well, I mean, you guys give me money, and a lot of you I don't know. But I'm not like, I don't know. It's weird. But then again, I can't really say that much against her. But at least I'm not doing it in my official capacity of my own job. That I'm doing this as Artie, not, my name, my official capacity with my job. Hey, give me money. Carl, thank you for the 19 months. And Ellen, thank you for the 6 months. So she done goofed. And then next on November 9th, on her official account, She posted a flyer for an event in Tribeca, which is a restaurant and bar in the Buckhead neighborhood of Atlanta. The flyer included a picture of Judge Peterson, said, special guest host, judge-elect, and owns Ready to Love, Christina J. Her name is Christina Peterson is her name. So she's promoting herself and promoting a bar on her official Instagram account. Wine Bottle Wednesdays. Woo! It wasn't a bar night, it was a professional night. And this is the most egregious one that we're probably going to have a little bit more of a discussion about. But this is the most egregious thing I think of when about her using her social media, because this is on her Twitter account. Between March 5th, 2020 and December 28th, 2020, Judge Peterson had a video available for viewing on her Twitter account, which portrayed her in a mustache. The caption on the video read, "Word of the day, homeless sexual." The word of the day. Let me just zoom in a bit here right quick. The word of the day portrays Judge Peterson speaking with a strong Southern accent, acting like she's giving an individual by the name of Yaniqua relationship advice. Judge Peterson's character tells Yaniqua that she didn't want to hear about it no more. Don't want to hear about DeAndre. What you got there, Yaniqua? You've only been doing this dude for 3 days. 3 days, Yaniqua. What you got there is a homeless sexual. She continues stating, that man says he's in love with you. That man will do anything for a place to stay. You made that bed with that homeless sexual. During the video, Judge Peterson also makes reference to the male genitals, specifically an African-American male genitals. So this complaint involves her kind of leveraging her position in a lawsuit against her HOA. It's not terribly sexy, but it also involves her allegedly taking money from members of the community who are trying to join her in suing the HOA. Including threatening them with lawsuits. This involves dealing with foster care. Okay, here's the next one. On Saturday, April 17, 2021, Judge Peterson was scheduled to perform a wedding at the Douglas County Courthouse. The Douglas County Courthouse is closed to the public outside of normal business hours and on the weekends. For after hours or weekend events where civilians will enter the courthouse, the Douglas County Sheriff's Office schedules and pays deputies to be present to conduct security screenings of civilians before they can enter the courthouse. On Saturday, April 17, 2021, deputies were scheduled to be at the courthouse to conduct security screenings and civilians for Judge Peterson's wedding, which was set for 11 a.m. per the schedule distributed to them. The deputies reported to the courthouse prior to 11 a.m. and left at around 12:45. Captain Trent Wilson was notified that Judge Peterson and her wedding party did not appear at the courthouse during the time frame and that the scheduled deputies were present. Captain Wilson then called Judge Peterson to advise that the deputies had reported for their assigned time frame and departed after Judge Peterson and her wedding party did not appear. Judge Peterson told Captain Wilson that she and her party had not yet appeared because the wedding was set for later that day. Captain advised the deputies had reported at the correct time per the schedule they received. He informed the judge that the deputies would not return to the courthouse that day. The captain advised the judge that she could either hold the wedding outside on the courthouse steps or reschedule the wedding for the following week. Captain Captain Wilson made clear that per security protocol, she was not to allow civilians to enter the courthouse for the wedding, as there was no deputies present to conduct the required security screenings. Goodness. Judge Peterson told Captain Wilson that she was going to do what her wedding party wanted to do. Captain Wilson reiterated that she was not to allow civilians to enter the courthouse. Captain Wilson further advised that allowing the civilians to enter the courthouse without the required security screenings would constitute a violation of the court's security protocol. Judge Peterson subsequently arrived at the courthouse and discovered that an off-duty deputy, who was also a pastor, was at the courthouse prepping to perform a separate wedding. Judge Peterson then called Sheriff Tim Pounds, the sheriff of Douglas County, to tell him about the situation. Sheriff Pounds advised that allowing or taking civilians into the courthouse without a deputy conducting the screenings would be a violation of the security protocol. Judge Peterson advised the sheriff that his pastor deputy was at the courthouse so he could do the security screenings. Judge Peterson then allowed 7 civilians into the front entrance of the courthouse. The first 3 civilians were not with Judge Peterson's wedding party. The subsequent 4 civilians were with Judge Peterson's wedding party. The pastor deputy was not present when the 7 civilians entered the courthouse. The pastor deputy did not conduct the required security screenings as he was off duty, not authorized to conduct screenings at the time, and was preparing to perform a separate wedding. After, and a footnote, after review of his activities, the pastor deputy was disciplined for allowing civilians into the courthouse without appropriate security screenings, which was a violation of the courthouse security protocol. The first 3 civilians that Judge Peterson allowed in were walked freely through out the courthouse without an escort. Judge Peterson conducted her wedding ceremony and then left. The chief judge was notified of what she did, and he advised the sheriff's office to suspend her after-hours access to the courthouse. Once Judge Peterson realized that her after-hours access was suspended, she sent the sheriff and Judge Emerson multiple email communications regarding her after-hours access being restored, never once acknowledging her violation of the courthouse security protocol. On April 21st, 2021, Judge Emerson sent Judge Peterson an email explaining why he suspended her after-hours access to the courthouse. Judge Peterson responded to Judge Emerson, this is the chief judge, by the way, via email, "How are you even a judge?" Judge Peterson continued stating, "This is definitely not becoming the judiciary, and you should be ashamed of yourself. This is harassment, prejudicial, and borderline racist. I pray that your soul is saved, and I also pray that the sheriff will know his authority and use it for good. Denying access to my office in the courthouse is denying me access to perform my constitutional duties. You have no authority to make the decisions in which you attempt to make. Please retire as this county has outgrown your spirit." Holy. That's wild. She copied her email with other court and government officials. Oh my God. On April 21st, the same day, Judge Peterson had a member of her staff sent frivolous requests for judge after-hours courthouse access for authorization. They were for 5 o'clock, April 22nd, 8 a.m., April 23rd, 5 p.m. Oh, excuse me. 5 p.m. to 11:59 p.m., April 23rd, 12 a.m. On April 25th, and 8 a.m. on April 26th. Ooh, my birthday. Per the sheriff's offices, each of these after-hours events required that 3 deputies be present at the courthouse. After appropriate steps were taken by the sheriff and Judge Emerson to address Judge Peterson's violation of the security protocol, her after-hours access to the courthouse was restored on April 22nd. Only a day? Man. With that email, yo, I don't know if I would do that. That was a very disrespectful email to the chief judge. What? Okay, so on April 22nd, Chief Investigator Lance Alfred and Deputy Director Courtney Veal went to the probate court of Douglas County. She's a probate judge, by the way, or she was a probate judge. Once they entered, they approached the counter and were greeted by a clerk. Investigator Alfred identified himself as the chief investigator and requested copies of marriage applications and certificates. Judge Peterson was not at the office at this date. After investigator Alfred identified himself and made the request, the clerk asked that they wait and went into an office out of public view. Several minutes later, the clerk returned and advised that Judge Peterson's policy required such requests be made in writing on letterhead with an explanation regarding why the copies of records were needed. The clerk explained that once written request was received, Judge Peterson would review it to determine whether the copies would be provided. When asked for a written copy of the policy or where one could look to review the policy, the clerk advised that the policy was not written and it was not posted anywhere for review. He then asked to see if they could at least view the records. Apparently, that wasn't allowed either. Oh, excuse me. You still had to follow the policy. At or about the end of April 2021, Judge Peterson obtained new case management software for the probate court. The new management software required that all information and data stored on the existing case management software be extracted, converted, and uploaded to the new software. On or about April 27, 2021, the county network administrator advised Judge Peterson that he had uploaded all of the files in the manner in which he was authorized to do so to her new case management software. On the same date, dissatisfied with the format in which the files had been uploaded, Judge Peterson sent an email titled Notice of Intent to Sue the Douglas County's Director of Information Services and the county administrator. So she's wanting to sue the IT guy. Copying other court and government officials. In the email, Judge Peterson advised that she was trying to avoid legal action, but her request had been denied and she intended to move forward with legal action tomorrow. Judge Peterson further advised, this is obstruction. You'll be sanctioned accordingly for non-compliance. She's also asked for a deputy escort every time she walks from her office to her courtroom and from courtroom back to her office. Okay. On or about May 11, 2021, Judge Peterson's deputy escort was a few minutes late to her office. In response to her deputy escort's tardiness, Judge Peterson activated the emergency panic button in her office. As a result, courthouse operations were disrupted and sheriff's office personnel rushed to Judge Peterson's office assuming there was an emergency, only to discover that there was no emergency. Judge Peterson advised that she had activated the emergency panic button simply because her deputy escort was late. So this is the last one I'm going to read out before we go into the video. And this is the one that's truly, I feel like it's probably among the worst of the allegations. On May 3rd, 2016, nearly 5 years prior to Judge Peterson taking office, I apologize to this lady. I cannot pronounce this. Prachabordi? Junongyai? Junongye? Prachabordi Junongye, I think. Filled out a marriage application in the probate court of Douglas County. When she filled out the application, PJ, who was born in Thailand, provided her biological uncle's name in the space for father's full name. PJ's biological father died before she was born, so her uncle helped raise her. Throughout PJ's life, she has routinely provided her uncle's name when asked for her father's name. On or about August 2nd, 2021, and on her own accord, PJ traveled to the probate court to inquire about how she could change the father's full name entry on the marriage application she filed on May 3rd, 2016. On August 2nd, 2021, acting pro se paid $60. PJ paid $60 to file a petition to amend their marriage record in the probate court. On August 2nd, 2021, that same day, Judge Peterson reviewed the petition and the marriage application and determined that PJ had willfully provided false information on her marriage application and lied under oath on May 3rd, 2016. On or about August 12th, 2021, PJ received a notice of trial or hearing from the probate court via U.S. mail. The notice, which contained petition to amend marriage record in the caption, provided that a hearing on the matter had been scheduled for August 24, 2021 at 10 a.m. The notice also provided you must attend in person. Video conference is not available for this hearing. The notice did not contain any information or mention of contempt allegations or a hearing on contempt allegations, nor did it contain any information or mention of the opportunity to consult with an attorney prior to the hearing. On August 24th, 2021, PJ appeared in person for the hearing with her husband. PJ did not have an attorney. During the hearing, PJ attempted to explain to Judge Peterson the reason for providing her uncle's name on her marriage application on May 3rd, 2016. PJ did not scream, yell, disturb, or otherwise obstruct the hearing in any manner whatsoever, nor did she hinder or threaten Judge Peterson's ability to conduct the hearing. Thank you, Deacon, for the $2. PJ was not advised of the contempt allegations. She was not afforded a reasonable opportunity to respond to the contempt allegations. She was not informed or permitted to opportunity to consult with an attorney about the contempt allegations. At the end of the hearing, Judge Peterson held PJ in contempt of court, finding that she was in blatant disregard of the laws of the state of Georgia and of the court, evidenced by her fraudulent misrepresentations to the court via her filings with the court, and ordered PJ's immediate arrest and jailing. Judge Peterson ordered PJ jailed until 11 a.m. on September 13, 2021, but provided that she be allowed to purge herself from custody on or after 11 a.m. on Thursday, August 26th, upon the payment of $500 fine to the court. She sentenced her to 30 days in jail for allegedly willfully lying about her marriage certificate. But even if she could purge herself of the custody, she would still had to spend where is it? At least 5 days in jail and pay a $500 fine. Immediately after PJ was arrested in Judge Peterson's courtroom, her husband went to the probate court to pay the $500 fine, but he was advised that he would need to pay the fine in cash. Wait, what was the date of it? Oh, it was October. Sorry, it was 2 days. Sorry, I thought it was 21st. Never mind. He immediately went to the ATM in a courthouse and withdrew cash, took it to the probate court, and paid the $500 fine. PJ still had to serve 2 days in jail, which resulted in unexpected separation from her husband and young child, and unplanned absences from work. That is probably the most egregious, among the most egregious ones. I'm not the most egregious one. I don't know if that's actually been, well, it can, Deacon, unless she could give a really good excuse for it. Because 30 day, I mean, so You know what, I'll wait. I'll wait to until after we hear the so the witness that we're going to hear as part of these hearings is the woman, PJ. She testifies in the misconduct hearing. Now, the most egregious I don't know if those charges were dropped since the first formal charges. But a lot of the other charges related to general misconduct, incompetence, and so on. I'm trying to see. I don't want to say what it is until I see that it's actually still here. Still part of the allegations. Okay, I think they have been. I think the big charges were dropped, which was one second. I'm looking at the counts. Ah. Oh, okay. So maybe that was part of the HOA suit. Oh yeah. Okay. I'm sorry. I shouldn't have. I'm sorry. I should not have skipped over the HOA thing. Apparently, apparently she went on represented members of the HOA in a lawsuit against the HOA. They're alleging that when they apparently won a settlement against the HOA, Judge Peterson pocketed everybody's share of the settlement herself. She took all the money for herself. That's the allegation. She didn't inform them that she received the settlement funds, and she did not deliver to them the settlement funds. Okay, so that's what I'm saying. Like the other, it looks like this was the other egregious charge that that was alleged, but it looks like they were dropped, was that she was allegedly pocketing fees. So, for example, the application to renew the marriage license, it was initially alleged that she was pocketing those fees to herself and not sending it to like the general fund. But I think but those charges were dropped. Because I think they she successfully argued that those things, the evidence that they have of that happened before she took office. So they dropped those charges against her. But it's not like the charges that are sticking are you know, okay. So I'm trying to make sure and confirm that those were all dropped. This is about PJ, what she did to her. Okay, she allegedly failed to comply with the law when she appointed an attorney white at taxpayer expense and without any indigency determination to be paid out of the indigent fund to represent Ms. Mercado, a civil litigant and a non-Georgia resident. What the hell is wrong with you? A civil litigant, you're not entitled to an attorney with a civil litigant, number one. Number two, she's not a Georgia resident. And number three, there's no indigency determination. What? Oh, she had ex parte communications. Oh no. Gave her additional time to file an objection without notifying the petitioner. So she was basically in cahoots with the respondent. Well, not in cahoots, but she was basically favoring her. Yeah, these are all about Miss Mercado. Failing to, appropriately supervise their staff, make sure they're doing what they're supposed to be doing. Yeah. Okay, so they did drop those charges. All right, so now we're going to go to the hearing. And like I said, this is a very long hearing. There's like 6 days worth, and I'm not going to go through all of that. I'm only going to go through the opening statements, and then I want to go to the PJ's testimony. There. Oh God. Let me see if I can work this audio.
Or can I not? Well, what you can do is you don't even really have to worry about use this thing. Yeah. Okay.
Hold on. Let's see where we're going. All right. Oh God, muted. Oh, they're having technical issues too. Thank God I'm not alone. They're muted. No.
Okay.
There we go.
Go ahead. Assertion of the First Amendment defense. Okay. And I'll go ahead and say, I'm not trying to step on him making this argument, but I think one of the issues there is we've seen some federal cases and looking at these First Amendment things, which tend to indicate that you really have to object every time that something comes up, and it might.
Oh, someone asked what ex parte means. Ex parte communications means when you as like an adjudicator, either whether you're an administrator or a judge or like a mediator or arbitrator, when you are communicating with one of the parties without at least copying the other party or letting the other party know of the communication. Yeah, speaking speaking to a party outside of the presence of all parties. Exactly.
Might be that a standing objection is more important, but I don't want to get down the road to the Supreme Court and say, hey, Tate, you did not preserve that. So that's,
Well, if you help us understand it, we probably can give you a standing objection. I don't know that we'll
I'm going to put this at 1.25.
tell a witness not to tell us what your client said. Your client statements are likely coming in. They may be statements that can't properly serve as the basis for any action that we might recommend the Supreme Court to take. That's where the First Amendment argument would come in. But I don't intend to set up a trap where, because you didn't object contemporaneously, that it's waived. That wouldn't be our goal here. Our goal would be not to have you object every time a witness says, well, that's when Judge Peterson said.
Hey, Seth, I see you.
I don't intend to do that at all. I think that, again, what we're talking about is sort of preserving the First Amendment, but the First Amendment issue, and if that's preserved, throughout. I want the objection preserved as to the opinion, too.
Right. Well, what's an example? Either one of you can give us. What's an example of an opinion you're worried?
Can I just produce for you a case that would establish?
Not so much the case.
Well, the reason is it addresses exactly what the opinions would be. What we're saying is, all right, I'll summarize it. I have authority for this. The court is interested in seeing it. It's this, is that the rule on opinions for lay people is that it's got to be helpful. And they're obviously taken in the context of a jury, right? Not a judge, not a bench. This. However, the rule still stands that it has to be, the opinion can only be allowed under two circumstances. One is that the witness has no other way to describe all of the facts other than introducing some sort of opinion. You often see that in cases of speed or a slip and fall case where they're trying to describe floor surfaces and it's confusing as to what's slippery. I think it's slippery, I think it's wet. And so it gets intermingled. That's one situation. The others, and we don't have that situation here, right? As far as the opinion.
This is her defense speaking.
We assume we're going to be offered. The other
the judge is right here, in the red.
Situation is that it's helpful for the determination of you all out there. And in the context of a jury, what this means is that if the witness can establish what facts they see or what facts they're trying to authenticate in the way of a video or something you've seen in writing, they can simply say, this is what I saw. And you, as the finders of fact, can make a determination of what was seen, whether it fulfills the standard of violation that the JQC is offering, or doesn't. You don't need the witness to tell you their personal feelings about how it affects them. So that encapsulates the objection on opinion. The other
Deacon, thank you for the $5. All right, last question. I hope, will she be able to practice law after any of this? I actually don't know if they're going to pursue further. I'm going to give you guys a spoiler. They did find her in violation. I don't know if it's, but it was recent, so I imagine she's appealing it. But I think she's already been removed from the bench for the time being while she's trying to appeal her situation. I don't know whether or not they're going to push forward to affecting her license, but she is not on the bench right now.
other thing about it is that any opinions as to what that speech would convey and so forth, that of course then moves over into the First Amendment. And let me address the first. Does that give you the example that I asked? That you asked?
Except it's not an example. So I understand the law, and we don't need the authority. What's an example from this case that you foresee witness X would be saying? Well, my opinion was that Judge Peterson was wrong to do that.
Exactly. There's that. There in these particular cases, they are saying in the affidavits and the offer that we have seen is that they're submitting complaint forms where the witness is coming in and saying, well, I saw this video or I saw this Instagram and this was offensive to me and I find this totally unacceptable. And those types of examples that were contained, and there were several complaint forms that they offered. And so they're actually rendering opinions on what they think the evidence shows. I think that's not the fair basis of a lay opinion. And that would be a specific example.
Okay.
And as far as the First Amendment, do you wish me to move to that?
We can in just a second. We're having an audio issue. And Mr. Staggers, you can come up here if you don't mind. Thanks.
Who dis?
Maybe so. I don't know. But Richards was on. Are your microphones, are the green lights on your microphones?
Two greens here.
Okay, all right.
Audio issues.
No, it's,
And there's one on the podium. I can see the green one on the
Yeah.
podium too. So
okay. Give us 1 second. Once this works, it's good for the rest of the days we're here. Be eliciting opinions that I hope that the director wouldn't be, we're good. Eliciting opinions that fall into the category of, in your opinion, was that a violation of the rules, or was that the wrong thing to do, where it's someone is weighing in on the propriety of action as opposed to, well, did it seem hot in the room? Something like that, where they're offering it something that's more of a present sense impression. But in general, we intend to apply the rules of evidence that allow in certain forms of opinion and exclude others. If you know something's coming, we also may want to have a sidebar to work through it. It sounds like there are a handful of witnesses that you're particularly dialed in on, but let's talk about the First Amendment concern, because it sounds like they bleed into each other.
Now, obviously, I'm not going to make our First Amendment argument. That's not what you're requesting. You're requesting purely from the evidentiary standpoint of the admission of certain testimony that may bear on speech.
Right.
And the argument is this, and I will be very candid with this court here, and that is that the law on this is not well developed. So, as far as me submitting to you conclusive authority on what I'm about to argue, there isn't any. There's a lot of dicta out there, and I did not feel it was appropriate to just cite a lot of dicta. So, this is the argument. The argument is this, is that as a fundamental principle, only relevant evidence that would relate to a violation of a charge should be admitted. Number one. Number two is that would mean evidence that is properly presented to this court that would reflect an improper use of speech to support the charge. Three, if that is the case, then that means this court must make a determination of whether or not the evidence related to speech is in fact governed and protected by the First Amendment. Fourth, that means that you have to make that decision as to whether or not you're going to use her speech, which is constitutionally protected by both the First and Georgia State Constitution, to convict her of a charge.
Wouldn't that be argument?
So but the problem is that I think the judges are about to say this. They're trying to say that they're trying to object to the idea that they may be using her speech against her, and they're saying that there's a First Amendment protection about that. But the problem is like, when you're a judge or you're an attorney, you have, in a way, fewer First Amendment rights than a layperson. You are supposed to be held to a far higher standard, not far higher, but a higher standard of conduct as an attorney that does not disparage the profession. Think of Ron, for example, that Ron Durbin guy, about his conduct and the way he acted. So I think that's where they're going, but I don't know. I think that the judge is going to say, well, like part of determining whether or not she violated the rules will be an analysis of her speech, including her personal speech.
You make at the end, though, as opposed to the way I read the eliminate was it shouldn't even come in at all.
That's correct, and that's the way I meant it. And you're absolutely right, and I'm doing that for this reason. Because as I told you, this law is developing, right? And the problem is that the dicta in relating to this, and let me give you the context of where it comes in, the cases that I have. Harris case. The prosecution wishes to establish that a parent knew that a child was going to potentially do a terrorist act. The parent comes in and testifies that I would never let that happen. My child wouldn't do that. We don't allow that in our house. That's the context. The prosecution then goes up and says, didn't you go to a meeting and say, to some radical meeting that was suggesting that the government was terrible, that they had ill feelings towards the government? Well, the issue that was raised before the court, which didn't get addressed because it came in under a different rule, but the argument was, how can you use evidence that's protected by the First Amendment to prosecute someone or impeach them? If that person had a right to speak, which they do, and the court said,
Wouldn't that?
how do you then allow the court to even consider that evidence?
Okay. I hear you.
What? Of course you could be impeached by things you say later. What? What? Like if I testify, you know, man, I would never ever kill that guy. But then the prosecutor comes in, well, hey, about 2 weeks before the murder, you posted on Facebook saying, I am definitely going to kill that guy. They're saying that they can't use my public Facebook post against me to impeach me? Well, this is a stretch that they're trying to pull here.
I'll be interested when a court opinion comes down that says you can't impeach someone with their own words. We're going to need to see this contextually.
Exactly. How would you impeach somebody if you can't? Like, your ability to impeach somebody would be substantially reduced if you couldn't use their own words against them.
But that's what impeachment is all about. In one breath, you say, I wasn't there. And then another breath, you say you were there.
Yes,
you are free to say I wasn't there. You're free to say I was there. But if you say things that are opposite, the fact finder gets to hear that you said things that were the opposite in evaluating your credibility. So I guess we'll need to look at this contextually.
And the reason, though, that I brought into all those facts is to let you know that as part of the opinion in addressing it, they emphasize that it's important. It's important that the attorney making the objection raise the First Amendment. And this attorney had not.
Okay. You have protected your client's rights by raising it on all these different angles.
Thank you.
Ms. Veal, is there anything you want to add on the opinion concern? I think the way we're going to handle it is question by question. Should it come up?
Your Honor, I just want to note for the record, we had a little bit of conversation during our meeting where we went through some of our evidence. And part of what I explained to respondents' counsel was that we have to prove that Judge Peterson on several different occasions violated Rule 1.2A, which requires that judges act at all times in a manner that promotes the public confidence in the independence, integrity, and impartiality of the judiciary. And I think an important component in proving up those violations, an important piece of this for the finder of fact, is to hear from those people who saw the posts on social media, saw how she behaved at the HOA town hall meeting, and to explain to the finder of fact so that you have it to consider and so that it's in the record for consideration when it goes up to the Supreme Court, whether or not the public confidence and the integrity of the judiciary was impacted based on her conduct. And so I do intend to elicit that testimony. I understand the rules of evidence fairly well. I don't intend to enter into evidence, for example, the filled out complaint forms unless and until they become admissible for something.
Yes, John.
I think a way to summarize,
as well as other civil servants, to again, not like their First Amendment rights are completely obliterated, but they're.
The way we're going to approach this is that, of course, any judge is free to say anything she wants. They're not necessarily free from consequences for having said what he or she wanted to do. And we need to work through what the consequences might be, if any, for having allegedly said something. And part of what we're going to do tomorrow and maybe into next week is, was something really said? And what are the consequences of having said that? That's the reality of becoming a judge, is that your freedom to express yourself as you may want to becomes.
Oh, sorry, I missed that. Akira 808, thank you for the $4.99. As per the First Amendment, I am auditing this live stream. That hugs and tummy rubs for the kitties. Yeah, Arch. I gave Winston his final medication. I need to give Mike his final medication, but he's hiding in the closet right now.
Limited in certain ways if you don't want there to be potentially adverse consequences, depending on how you present yourself. The second motion in limine was related to social media, and it was a blend of, it sounded like foundational authentication concerns, and then the whole First Amendment popped up again. So I think if there's a proper basis or foundation laid for an Instagram post that it is associated with an account that the evidence shows pretty clearly is Judge Peterson's account, I don't know why there'd be authentication issues. We may then have First Amendment concerns, and you've lodged those and you can renew them. You're not waiving anything if you don't renew them every time. But again, what a judge says on her.
You can take it for the $10. Okay, this is for my educational purposes. Would this be considered a special trial because there's another judge almost done with the semester and looking for examples of different trials? Yes, this is not a hearing on like basically the judicial disciplinary committee, like the Georgia's disciplinary body procedure. This is a hearing for that. So it's not criminal, it's not civil, it's its own procedural aspect for members of the judiciary. And it's a 3-person panel who
Her
adjudicates.
social media while she's a judge can have consequences for that judge, depending on what's said. That's not a profound observation coming from the hearing panel.
I think the motion to eliminate was just to assure that we preserve our rights in the case that what is presented as the alleged Instagram is in fact her.
Sure.
And that the material on it has not been modified or additional language added to it.
Sure. Or as some of these work, and I only understand it quite dimly as a non-social media person, you could have a stream and someone post something on your stream, and that's not you. That's someone saying, I follow you and check out this thing I'm following. And then all of a sudden on your stream is what someone else is following. And so
All of those sorts of things. Yeah, that's what I'm concerned about. And thank you. You have it.
okay. Well, I don't have it, but at least we're
Our argument. Yeah, you understand. Yeah.
okay. There was a motion to exclude a video in which someone else, as I understood it, says in the video, Ms. Peterson is a judge. Not that Ms. Peterson says I'm a judge, but someone else says, hey, she's a judge. That's sort of out of context, but I wasn't quite sure how to work through that. People may say what they
Have me. I'm not sure exactly the context that we were doing that also. I mean, obviously,
Agreement we have about the law. We're not nasty with one another about this. And when I said, yeah, I plan on coming,
All right, I'm going to try and move ahead and see if they actually do the formal beginning here.
Cancel it and do something else that could.
No,
But
understood. They didn't walk in the room and there you were sitting, not a potted plant.
I'm just trying to remember over 19 years what our precedent would be on the, and I don't remember.
I think that meeting has changed over those 19 years because there was a time we did not have a court reporter present.
Right.
There was a time when it was more like a mediation than a grand jury type proceeding. And that's sort of evolved and changed over time, which is fine. That's what happens with the law. But I think if there's a witness statement that's taken there, by the way, too, at the investigative panel meeting, we were invited to be at the investigative panel meeting to speak to that. And I made the request, and I made the request to the whole panel. And they politely ushered me out and I politely went, but I felt like I had to perfect the record about that.
Okay. All right, we will circle back on those two transcripts. Let's talk real briefly about the director's 404B, and then we can get started with the hearing. So Ms. Villa, we've looked through the 3 items. It's social media, and really social media, but the third one is a video that was posted on an Instagram account. You listed 5 purposes, and I thought maybe you could flesh that out and then talk a little bit about the probative value, because ultimately that's what we're weighing. It's pretty clear how it's relevant to some of the allegations, but does that probative value, is it substantial?
Okay, so she's talking about her Instagram posts and specifically also about her Yaniqua thing.
Financially outweighed by prejudicial effect? I don't know. We'll hear from Mr. Tate and Mr. Chamberlain on that.
So, Your Honor, before I flesh out, let me narrow those purposes for which I am seeking admission of this evidence. I would like to limit to intent and absence of mistake or accident. And I included all of the purposes that in my head I thought may be arguable, but I am cognizant of the way in which the 404B case law is trending. So I would like to keep it narrow, and I'm sure the panel would appreciate that as well. So when Judge Peterson was initially noticed about the social media complaints, which all came in while she was a judicial candidate.
These would be complaints about we've seen some of it during the motion for summary judgment. Come to this, I'm going to get the facts a little off and we'll get them right, obviously, during the hearing, but come to this club or there's this event, but it was somehow associated with her campaign.
That's correct, Judge. There were 2 posts where she either posted herself or reposted an advertisement that a business had posted that contained photographs of her and invited people to attend an event. And within those posts, it said, you know, judge-elect or judge-to-be. There were hashtags related to her.
So this is about the her advertising herself to an event, and using her
So we noticed her on those two complaints.
social media
And
posts.
Other post that is at issue is the one that she shared on her birthday, also on her Instagram. I believe she shared it on other social media platforms as well. But the screenshot we have.
My birthday, cash at me.
Within the comment to the picture of her, she shares that it's her birthday and says that if anybody wants to share their quarantine wealth, to cash app her, and then inserts cash app.
She actually asked people for their COVID checks for her birthday. That's the audacity.
Into the post. And the last one is the video that we've referenced as the homeless sexual video. So she came to an investigative panel meeting voluntarily. We sent her a letter and said, hey, we have complaints, those 4 issues. She appeared in February of 2020 or 2021. So right after she got onto the bench. And within that investigative panel meeting, and I'm going to summarize where we got with her.
If I hate to interrupt, I apologize, but there was a question that was brought up about, I think Mr. Hyde asked for the investigative panel transcripts, and I objected to that because it's not subject to the rule of evidence. It's not subject to anything else. So my view about the 404B is it has to do with what the evidence is here, not what the questions were in the investigative panel, because Commissioner Hyde said, who's done this for a long time, there are all kinds of questions get asked in that situation. So I'm going to object to her going into.
Well, I can short circuit the debate because this has been very helpful, narrowing it to intent and lack of mistake. Those are the two that jumped out to me. These more recent social media posts allegedly occurred in July and August of last year, which would have been long after your client was on notice that judges need to be super thoughtful about how they handle social media. And these.
Oh, okay. So he's like, yeah, these posts are not when she was like running for office. These posts are after she's been in office for a couple of years, where she's supposed to know how she's supposed to conduct herself publicly.
Would be examples potentially of maybe not being so thoughtful about social media usage and letting the world know that you're a judge. So
which would, in my view, be wholly improper to admit it for, because that's not the purpose. They're talking about intent and mistake. Unless she testifies, oh, that was a mistake. I was trying to send a text to my friend and it somehow jumped over to Instagram. If you were familiar with the State versus Ross Harris case,
heard of it.
The Georgia Supreme Court was very clear that you cannot use 404B evidence to pile on additional charges to muddy the defendant up later on. And so what you just said, with all due respect, is, oh, well, this was after this notice. It's not part of the formal charges. It was part of the things that they submitted once, if not twice. I can't remember if it was both of them, to the Georgia Supreme Court in a motion for.
It doesn't want to be picked up. I'm sorry. At least not now.
Their motion was denied because of this. So unless she says, oh, I didn't really intend to do that, I just hit the wrong button, or, no, it was a mistake, I thought I was posting on something else. It happening after the fact is, and what you just said, Judge, is showing aggravation, not intent or mistake.
We'll work through it. I don't know that it's a real apt parallel, what happened with the Ross Harris case and the volume of what came in and the inflammatory nature of what came in versus here, but I appreciate the comparison.
Right. I don't have genitalia pictures to pile on, and I didn't blow anything up. But my point is that when she came to that meeting.
Wait, was that what the case is about that he cited? Oh my God. Wow. Veal is calling out. I mean, I guess I'm supposed to infer. We're supposed to infer that the inappropriate pictures. No, the inappropriate pictures were not on the same level. Yeah. What she's saying, what she's inferring, is that the pictures that were used as 404B, or what was at challenge of 404B, was about explosions and a dick pic. That's not what this is here.
In February of 21, she said, I didn't know that I wasn't supposed to do this as a judicial candidate. And so going forward, I won't do it because now I've read the code and now I know better. And now that's kind of transformed into well, it's my First Amendment right to do it. But as the panel is well aware, the decision in Coomer has made clear that we must demonstrate bad faith when we have a judge doing things or a judicial candidate doing things that do not pertain to their judicial duties.
And that's where I was headed when I started, and you didn't interrupt. It was fine to share what you shared, but ultimately, given what you must show, and we ultimately must find if we agree with your perspective on this, it certainly seems germane to that question of bad faith, which is partly intent, et cetera. So it's not as crystal clear as the defense was, I didn't know back then, or I hit the wrong key, or I had my publicist running my account and I told them to stop. So I now that you've narrowed it down,
Hey, Randy.
we have a better feel for the purpose of these things. The last thing I'll note is that we've all been told, whether it's hearing panel, investigative panel, et cetera, that Judge Peterson's case needed to move forward and not pause again because new complaints came in, and would they be added to amended formal charges, et cetera. So the fact that this information may have been used in connection with other steps that the director's office took, I don't think means they couldn't be brought up here. And the fact that they haven't materialized into a third set of amended charges, I don't think puts them off limits as long as it's a proper purpose. And it's sounding to me like intent and maybe lack of mistake would be germane if the right foundation is laid. I mean, obviously Judge Peterson or some evidence would need to come into the effect of what Ms. Veal just shared. But if that does come in, then I think we are in the right realm for this. Okay. Did you all want to add anything more on the motions eliminate? Again, we will take under advisement this question about the Caldwell and FASIC transcripts, and after the break, at the latest after lunch, but after the break, say they need to be handed over or they don't. Okay. Mr. Tate, Mr. Chamberlain, anything else before we start with openings?
Not for me, Your Honor.
Okay, Ms. Veal?
No, Your Honor, other than I know both sides pursuant to your scheduling order have prepared binders that contain all the hard copies of the exhibits that we intend to introduce. They're sitting right up here at the bar, and I just didn't want to forget to mention that.
Okay, great. Thank you. All right, if there's nothing.
Okay, now we're starting the hearing.
Why don't you, Ms. Veal, the podium or wherever you want to be for your open.
All done with the motions.
Your Honor, myself and Mr. Tate spoke briefly. At this time, we're going to go ahead and invoke the rule of sequestration.
Okay, so if there's anyone here who may be called as a witness, you need to step outside. Don't know who those folks are, but you know who you are. And we'll come get you, I promise, when it's your turn to testify. Thank you. Elijah, can we get those binders? Director. Yeah, so defense and or respondent into it. All right, Ms. Veal.
Can I present to judges at their conferences on judicial ethics? One of the things I normally lead with is our rule 1.2a, the Code of Judicial Conduct, and it tells us that judges must act at all times in a manner that promotes the public confidence and the independence, integrity, and impartiality of our judiciary. And I make sure to emphasize at all times. And I remind them that the commentary to that rule tells us that judges now more than ever are the subject of constant public scrutiny, and that judges should accept restrictions on their conduct and on their behavior that ordinary people, citizens, laypersons, people who don't decide to become judges don't have to accept necessarily. And the code tells us that judges should do that willingly. Judge Peterson's conduct since the time that she qualified for judicial office has been at variance to her obligations pursuant to our code. At every turn, she has demonstrated that she does not care what our rules say and she doesn't care what the law says. She's going to do what she wants to do for whatever reason, whether it's claims it's her First Amendment right, or it's not a violation of the rule, there's nothing wrong with it, I'm defending myself, it was my clerk's fault, I didn't know this practice was going on in my court. It's never her fault. We start off with the social media conduct that was reported by various citizens in Douglas County during her judicial candidacy. She qualified on March 5th of 2020. She had opposition only in the primary election. So after June of 2020, which she won the primary, she had no opposition for the general election, which occurred in November of 2020. And throughout that time, she posted things on social media or shared things on social media that were violative of the Code of Judicial Conduct. And she did so in several of them, adding her judicial status, hashtag judge to be, hashtag she's up next. And she did that for a reason. Judges are free to go to social events. They're free to go to professional networking events. They're free to go to bars. They're free to go to wine nights. That is not the issue.
Hell yeah.
Judge Peterson knows that's not the issue. The issue is advertising for those events at private businesses, at bars and at nightclubs, and attaching
In your capacity.
status to those advertisements.
Yes.
The issue.
That's the issue.
I'm going to post about my birthday. You can post about your birthday all you want. But then I'm going to ask for Cash App. The result of that, and I believe you're going to hear one version or another, is that people sent her money on Cash App. The result of that post, even though we've heard during the course of these proceedings that that was her private page or that was her personal page. Another thing I tell judges when I train them on judicial ethics is nothing that you put on social media is private or personal. I don't care if you have 5 friends. All it takes is one of those 5 friends to screenshot your birthday post asking for money. And that post will then exist for as long as they want it to exist in their camera roll on their phone. And it will be disseminated to as many people as they want to disseminate it to while they hold on to it. And what happened with Judge Peterson's birthday post was that a citizen in Douglas County saw it, screenshot it, then posted it to a Douglas County citizen page. And that is how the public at large started to talk about and started to see, hey, we have a probate judge asking for money for her birthday.
True, Aaron.
The social media post after she came into the investigative panel meeting in February of 21, where she said, you will not see this again. I won't advertise. I understand I have to do things differently. I have to move differently when I'm a judge.
Okay.
We start to receive complaints and information related to her behavior at the courthouse. In April of 2021, she decides to schedule a wedding to be performed on a weekend. There is a scheduling mix-up. It doesn't matter whose fault it is. There was a scheduling mix-up. The deputies that were there to screen the citizens, the people in her party that she was bringing in, left before her arrival. And as we all know, when citizens come into our courthouses, they have to be screened. They have to go through security. I think that's pretty common sense for anybody that, certainly for those of us that have worked in the court system, but even for the citizen who comes in. I think they expect that I have to go through screening because I'm different than the judges and then court staff and personnel and the people who work at the sheriff's office. I don't work there. I'm not associated with the court system. And so despite knowing and despite being told that she should not go into the courthouse and bring the citizens in without security screening, she did it anyway.
No. Oh no, one of the videos I had in my playlist is hidden. Shit. I don't know which one it was though.
The fact that when Judge Peterson arrived that day, there was an off-duty sheriff's deputy also at the courthouse on that Saturday performing a wedding. He also allowed in his entire wedding party without security.
Bro, all of these videos are like 8, 9, 7, and 8 hours each.
But guess what happened to him? An IA investigation and a suspension from work. Once the sheriff found out and once it was investigated.
Deacon, think of $5. I hope this is the last question. Who's allowed in the gallery in these types of hearings? I believe these hearings are public, but I imagine most of the people who are there are probably members of the press.
2 wrongs don't make a right. And certainly a judge, the one who works in the courthouse day in and day out, the one who we hope would understand how important it is to ensure that the citizens we bring inside don't carry anything inside that shouldn't be inside. That judge's obligation is greater than the sheriff's deputies. And she was specifically told, do not do it. Do not do it on this day. And she did it anyway. After that, her after hours access to the courthouse was revoked. He then decided, as she feuded with the sheriff and the chief judge is the one who made the decision to revoke her after hours access.
Guys, it's not about me not having the ability to download them. I can download them. The problem is that all of these combined is going to be like 150 gigabytes or some craziness.
Went back and forth with them, never admitting, hey, you know what? I get it. I recognize that what I did was unwise. And if I had to do it over again, I would do it differently. No, there was never any of that. There was just debate and threats of lawsuits for suspending the after hours access, which the superior court judge, the chief, has the authority to do. At that point, she decides to have a member of her staff make multiple requests for access after hours to the courthouse, running all hours of the evening, all hours of day and night. And she made those requests while she was gone out of town at probate judge training. Once she is back in town, her access after hours was restored, but it was only done after the chief judge and the sheriff got together and amended the security protocol for the house to control for after hours events at the courthouse. That exchange led into her sending the chief superior court judge of that county an email where she called his actions borderline racist, harassing, prejudicial, and told him to retire because the county had outgrown his spirit. During that week where she was gone at training, myself and our investigator at the time, Lance Eckford, went to the probate court to attempt to obtain records related to marriages that Judge Peterson had done. We asked for the records. We were eventually told by the clerk that any request for copies of records had to be made on letterhead, had to identify the purpose for which we were seeking copies of the records, and had to be reviewed by Judge Peterson. When the request was changed to, you know what, we don't want copies, we just like to look at them, we received the same response. This is the judge's policy and this is what you must do. So we left there with no records in our hand that day. Judge Peterson gets back in town, calls investigator Alford goes to meet Judge Peterson, and she has a clerk pull up the records and provide them to investigator Alford during that meeting with no trouble at all. Another example of Judge Peterson's conduct being at variance with her obligations, and you'll see this woven throughout the case, is her inability to work with and professionally resolve issues with court staff, court personnel, other judges. She gets a new case management software system. There is an issue with transferring data from one system to another, issues about the contract with the provider that already had the information. And in response to her frustration about that data being migrated to her new system, she decides to send the director of the information system group.
Notice the sue.
Email subject line, all caps, notice of intent to sue. She
All caps, drink.
She gives the IS department a directive to give her the information that she wants, even though the IS department has said, we cannot give it to you in that format because we would be violating our contract with our current provider. She tells them what they are doing is obstruction and essentially orders their immediate compliance. Judge Peterson, during her time as probate court judge, started to request a deputy escort from her office to her courtroom. Fine, she can request that. He was late one day. She decides to push the panic button in her office, and her explanation for why she pushed the panic button in her office, causing multiple sheriff's office personnel to go to her office, was my escort was late. We then fast forward into, and you know, some of the matters that have come before this panel, we have missed that piece of how does this judge act when they're on the bench, and how do they preside over cases, and how do they treat the people that come before them? How do they handle issues that come before them? How do they act when they're doing things as a judge? You're going to hear in multiple instances that in August of 2021, Judge Peterson received a petition from somebody who wanted to amend information on their marriage application being filed in 2016, 5 years prior and under the prior probate court judge. In response to that, she orders this woman to an in-person hearing, and the hearing notes
Hanks,
you cannot attend.
Alexandra.
You must come in person. This is a hearing on a petition to amend your marriage application.
It's almost like I'm.
No mention of contempt, no mention of any allegation related to contempt, no mention of attorney, none of that. She gets there. Judge Peterson asks her about the information she previously provided. She put her biological uncle's name on the original, and she was now changing it to her father's name. Judge Peterson decides to hold her in contempt and impose the maximum penalty for contempt, 20 days jail and a $500 fine. Because according to the order Judge Peterson issued at the time, the petitioner had submitted fraudulent information when she submitted her application in 2016. Well, on the back end, Judge Peterson will say, well, she admitted to me in court at the hearing that she had lied under oath in 2016. And she also attempted to give me an
20
illegal
days
document. What is that illegal document? It was a non-official translated copy of a birth certificate from Thailand. And it was all she had.
Oh my God, I forgot about that part. She also yeah, she had like a non-certified copy of her birth certificate. She threw her in jail for that too.
Told her if she did not get an official transcribed copy of the birth certificate and get to her, that she would go back to jail for the remainder of the 20 days. So the sentence was 20 days, pay a $500 fine. Her husband immediately paid the fine and she was allowed to purge herself of the contempt after 2 days. So she gets out, has 18 left. But if you don't give me this other copy of your birth certificate from Thailand, you're going to do the remaining 18. We had a petition for ear support filed. The presumption under the law is that the petition for ear support by the surviving spouse, they're normally granted to support the spouse during that time. Some 15 months later, after Judge Peterson's recusal, Judge Bo McLean, who ultimately presided over the case in Superior Court, found that the caveat that Judge Peterson allowed was not timely, should not have been allowed, and the petition should have been granted. And you'll hear more detail about the petition during the course of the evidence. The last thing is that, and you've heard a little bit about this, and you have the transcripts related to Ms. Caldwell and Ms. Fazek's involvement. We have an individual who filed a petition for letters of administration. It was not contested. All of the heirs agreed. We're fine for our sister to serve as the administrator. We want to get it done. Our dad has died. We need access to his bank accounts, and we need to be able to have access to his home. We're stuck paying the bills until this is granted. Multiple calls by the attorney to the court to inquire about the status of the matter since it was not contested. Nobody was objecting. Has Judge Peterson signed the order? No, she hasn't. It's on her desk for signature. Has not signed it. It's on her desk for signature. Has not signed it. It's on her desk for signature. That attorney.
Oh, wow.
Filed a petition for a writ of mandamus to ask Judge Peterson to rule on the motion. Lo and behold, an hour and a half after Judge Peterson was served with the writ of mandamus, the order's been signed. And the attorney is notified, hey, you and your client come to the court to take your oath, and we'll do the letters of administration. They get there during the course of her taking the oath and the paperwork being signed. The attorney and her client both observe Ms. Caldwell adjust the manual file stamp back to January 18th, which is the date that Judge Peterson has signed the order in the case, and that's the operative form here, the order. It was signed and dated by Judge Peterson January 18th. She adjusted back to date January 18th. This was stamped in. This was done on January 24th. And they watched her do that. I expect the evidence will show that Ms. Bates in that court since before Judge Peterson took office, and I expect that she's going to come in here and say, that's just what we did. We manually adjusted the filing stamp to match whatever date the judge writes on an order when it gets to us.
She backdated official documents.
Evidence in this case. Again, that you will reach the conclusion that Judge Peterson's conduct, again, from the time she qualified, as she sits in here today, has been at variance with her obligations under our code.
They can take over the $5. Okay, modest adjustment with the court. Have a mic that a lawyer can walk around with. That can be clipped on the lapel. True. I imagine a lot of courtrooms have already done this, but I don't know. We'll see.
Thank you.
Thank you, Ms. Veal. Mr. Tate and Mr. Chamberlain, you should know by default, we're probably going to say Mr. Tate. If it's something you're handling, you can pop right up.
Okay.
We'll just say Tate, and then you guys decide who's doing the talking.
Yes, gamer.
I had understood the panel asked us to limit our remarks to 10 minutes, and I will do my best to do that.
Thank you.
Mr. Chairman and members of the panel, Judge Peterson is the first African-American to serve as the Douglas County probate judge. She is the first attorney to serve in that position. As you know, the law requires that over a certain population, and Douglas County had gone over that, and the predecessor retired. She was also named the probate judge of the year by the Georgia Association of Black Elected Officials. Notwithstanding these accomplishments, she stands before you accused of doing all these things that Ms. Veal has just said that they want you to use to overturn the will of the Douglas County voters.
Robbie, yes, she does. We're not going to go into that. I do want to listen to her testimony because I heard it's pretty wild, but I want to explicitly go to JC's, or was that her? JP's testimony. She was the one who was sent to jail for contempt for trying to amend her marriage certificate.
Elected her. It's not unusual that elected judges
DJ, JP.
have elected judges
DJ, JP.
have people in the community who would complain about them. You only get a 50% satisfaction rate as a judge. And if you run in an election in this time, particularly if you run in a partisan election, Judge Peterson was the Democratic nominee. You're probably, even though you get 50% of the vote, you've probably got some substantial group of people out there who are displeased with you. And you will hear testimony from many.
But she ran unopposed. If she ran unopposed on the Democratic ticket, I feel like that suggests to me that it is a very, very, very safe blue county.
Many of these disgruntled people, because they began filing complaints before Judge Peterson was ever stood before anyone to take the oath of office. They filed complaints about things that were more like something an opposition researcher in a political campaign would drudge up.
It doesn't.
That a respectable body of judicial discipline would inquire into. There's a great. I'm a fan of the Spoon River anthology. I don't know if any of you read it. I highly commend it to you, but it talks about one judge and he says he's a picker of rags in the rubble of spites and wrongs. And I would submit to you that the people who are complaining about Judge Peterson are people who are pickers of rags in the rubble of spites and wrongs. They're not offended by Judge Peterson's conduct. What they're offended by is the fact that Judge Peterson holds office.
The motivations behind the complaints have limited relevancy at best. What matters is whether or not she engaged in improper conduct. Aaron Hamilton, thank you for the 23 months.
And so then we will go and look for something that we can say, oh, I think we've got you now. We've got you now. I want to give you an example because we've talked a little bit about charges and charges that were dismissed and charges that weren't brought forward. Judge Peterson has been a foster parent for many years and was a member of a foster parent group. And she was one of the people that was on committees and did stuff for the foster parent group. So when she goes to her probate judge training, she asked, can I continue to do that? I'm a juvenile court judge. I don't really have anything to do with kids. Can I continue to be a foster parent? And Judge Peterson heard some mixed ideas about that. I think it's very important because Ms. Veal wants to talk about, this is what I go and train these judges, and this is what I tell these judges. So Judge Peterson was still in doubt, and she came back and she called the JQC, not Ms. Veal, but the predecessor, and said, I was at this meeting, I asked about this. And do you know what the response was from the JQC? That's not what was said at the meeting. We're going to file a charge against you for calling us and asking this question after we told you what to do when we were at this training. That's what the response was. Now, for all of this alleged goodwill, and Ms. Veal, to her everlasting credit, when she became the director, she dismissed that charge. But when you talk about intent and what people are trying to do, never heard of the Georgia Judicial Qualifications Commission filing a charge against a judge for asking a question until it was Judge Peterson.
So he's trying to argue that because that charge seemed pretty frivolous, it's going to call into question all of the other charges as being like spite driven. But being spite driven, again, it's limited. It's kind of limited in your relevancy if there's a lot of evidence supporting the charges.
So you've had other judges that come before you. Some of them have claimed, and I appreciate the court's wit, that they had a cabal of rival lawyers after them. We're not saying that the JQC made her do any of the things she did. In fact, a large portion of what you will hear has to do only with what microscope you're going to examine that under, how you're going to look at that.
Okay.
The charges that they've made, and again, they have made these as so serious a charges. And I say this because Ms. Veal has gotten up here and said, oh, just listen to what we've had to do. Let me tell you what they did. Twice they went to the Georgia Supreme Court and they said, Judge Peterson's so bad, you need to suspend her on an interim basis. Both times they lost. Both times they lost. And as the court alluded to earlier, one of the things they said is some of these don't seem very serious, others might be, and she's entitled to a trial, and we're getting that here today. Let me talk for just a minute before I address some of the other things, some of the specific facts about what that lens is through which you're supposed to view this conduct. Because
Hello, M3.
recently there is what I think we would all agree, a sort of landmark decision from the Supreme Court in the Coomer case.
Which case was that?
The Coomer case. You might have heard of it,
Coomer.
Commissioner Hyde. And
Sorry.
in that, the court said longstanding precedent makes clear that although actions taken in a judicial capacity, acting as a judge, not merely while a judge, can warrant discipline regardless of good faith, actions taken outside the judicial capacity can warrant discipline only when taken in bad faith. Unlike the Coomer case, there are both things alleged here. There are things that have to do with decisions on cases, and there are also things that have to do with social media, with African-American networking events, with all of these other things. So I want to say that if you're not going to be an opposition researcher, you can't just stand here and say, this is what Judge Peterson did, and ipsy dixit, because I say so, this is bad, and this brings disrepute upon the judiciary. You've got to have some proof of that. In fact, that's what we argued twice and won on in front of the Supreme Court. There is also the very prescient issue of her having been charged for several actions under the Judicial Code that involve speech, which is artistic or satirical expression. And we contend that these charges violate her constitutionally protected rights to free speech under both the U.S. and under the Georgia Constitution. For example, she had posted a satirical video before she was a judge, and before she was a judicial candidate, and she will testify about that. I think although it was still up, she had not taken it down, in which she does a little skit of satire, has a mustache on, and they claim that this brings the judiciary into disrepute. We all know that the Atlanta Bar Association has a bard show. Some of you have participated in that. I've been the subject that's been lampooned in the bard show before, and satire is a protected form of speech. Unless, of course, you're Judge Peterson and all these people want to play the gotcha card. With regard to questions, and I'll specifically address some of the specifics now. With regard to holding somebody in contempt, I was on a panel with a member of the Supreme Court, and I said, I'm not sure there's a judge in Georgia that really knows how to actually hold somebody in contempt the correct way. And he said, yeah, I think you may be right.
Okay.
And if you look at what she did in that case.
I was affirmed twice for holding people in contempt, so there might be one, or there used to be.
There used to be.
We probably have the two judges that know how to do it right sitting here. Mr. Hyde, although not a lawyer, could probably do better than some, but there are multiple ways. As you know, there's civil contempt, there's criminal contempt. And so again, with this, and the testimony will be that she called colleagues or reached out to other colleagues on the probate court about what to do on probate.
Kira, thank you for 499. Are judges held to a higher standard? Yes, she should be a judge considering that she thinks that she has done. You know, everybody's got stupid things they've done prior to coming into office or, becoming a lawyer, and you are therefore held to a certain standard. So, but a lot, if not most of this conduct, or actually all of this conduct happened either after she was elected or while she was in office.
Courts in other places before she took this. But this is a ruling of law which allows for an appeal. What's the Supreme Court said about that? I had some experience with that, as well as Mr. Hyde, in Judicial Qualifications Formal Advisory Opinion 239. And one of the principles that the Supreme Court set forth in that is the law is not always easily discernible. And when the law is unclear, unsettled, an honest misunderstanding or misapplication of the law does not implicate the code of judicial conduct. Legal errors only amount to judicial misconduct if a reasonably prudent and competent judge would consider that conduct obviously and seriously wrong in all circumstances. But not every error of law, even one that such a reasonable judge might avoid making, warrants discipline. Absent bad faith
Errors in judicial discernment and application of the law implicate canon 2 only to the extent that the pertinent law is clear and settled. What that tells me with regard to the individual that was held in contempt, if this was Attorney Lester Tate and Judge Peterson had a case against me in private practice and didn't like me and was mad at me and misapplied the law and held in contempt, that would be bad faith. And even though if it were in error, would warrant discipline. But there's no showing of any, that she knew this person before, that she harbored ill will toward them, that she gained some advantage by holding them in contempt. It's just a straight holding of contempt. And I've gotten a judge reversed before for holding a lawyer in contempt, and they're still sitting on the bench. In fact, there are multiple other instances that I was not involved in where that took place.
So again, I'm going to wait until after we see the witness testimony, unless they bring it up themselves, where there's a speculation as to the motivations behind why she threw the book at this woman, at PJ.
We talked a little bit about the marriage video. And I want to be clear about that. She was on her way, had set up to do a wedding in the courthouse. She talks to a deputy sheriff on the phone and says, I'm on my way. Oh, the deputies have already left. She suggests doing it on the courthouse steps. Deputy suggests, she says, I'm going to call the sheriff. I'm going to talk to somebody else. And you know what the deputy said? Not what Miss Veal tells you. Don't you do that. You can't do that. Do what you have to do. She gets there, and she actually asked on the telephone and says, well, couldn't you get a road deputy come in there? Oh, no, they're not familiar with the stuff. So she gets there, and there's a deputy that actually works security at the courthouse. He lets 13 people in. Judge Peterson went in with one bride and one groom. The 13.
They get to get it for the $5. Please remember, Chad, that this is what a defense attorney does. Yeah, I mean, he's got to roll with what he's got. Again, all of what I showed you are allegations. They're allegations that the JQC has to demonstrate.
People go in, she goes in, as well. The deputy didn't take all of the 13 people through the security procedures. This internal affairs investigation showed, I believe, not that there were one, but two deputies that did courthouse weddings, and they both had been doing them for years and years and years, and so they never took anybody through security. So the first time that we're going to start disciplining people for something that's been going on for years and years and years with deputies is when we could play the gotcha card with Judge Peterson. The Cash App request, and I do think Ms. Veal represented that correctly. Somebody copied it and put it out further in the public domain. The purpose of the post, Judge Peterson will tell you, was to commemorate her birthday, not to request money. The inclusion of that request had 3 laughing emojis after it, talking about quarantine wealth, because at the time there were people that had been laid off and people that were getting replacement funds from the government. At the time of the post, she was not serving in judicial office. 3 people on her birthday from 3 established friends who do not live in Douglas County sent money. One is a family friend and a mentor. Another was a family friend. And the third person was somebody that does not live in Georgia.
I thought it was while she was in office. Maybe that's a point of contention.
It's been portrayed by the JQC like, oh, she's taking a bribe. She's not a judge yet. None of these people even live in the same place. And one of them doesn't even live in the state. None of them have a case in front of her at all. And yet this is supposed to be grounds to remove her from the bench. The professional event hosting, and this is, where she is on Instagram. These are African-American networking events, and you will see the term BAE, which I believe stands for Black and Educated, and it is made for individuals who are not just lawyers, judges, doctors, executives, other people come together to do this. They do it, the fellow promoting it told what was available there in terms of what there would be food and drink there as well. She received no profit from doing that. They announced that she was going to be one of the people there that other people could network with and could meet. I'm at a loss to understand how this is any different from what happens almost one Wednesday night a month at the Lawyers Club of Atlanta, where judges frequently speak. And when they speak, they're advertised as a judge. There's no showing whatsoever, and will be no showing that she profited from this, that she was paid to host these events, that she fundraised at these events, or that attending this event was in any way unbecoming for the judiciary. It may be a more urban hip hop way of the Rotary Club that's in the country someplace, but all it is a networking thing that people do all the time.
I mean, I've been to a couple of clubs back in the old days. The advertisement that I saw that's used, that looked like your bog standard, Wednesday night drink specials or Thursday night drink specials, that this and that. Like it didn't like your bog standard advertisement you would see for every typical club that's advertising. It didn't feel like it was an actual networking event for professionals, but maybe that's my inner racism.
The Homeowners Association video. Well, let me back up for just a second. Ms. Veal has announced to you that a duly elected probate judge in a county had the temerity to say she might file a lawsuit to have a dispute resolved between her and the chief judge, or between her and the sheriff, or between her and the county commissioner. There are 159 counties in Georgia, and I'm pretty sure that some judge in just about every one of those has had a dispute with a county commissioner, with another judge, with the sheriff. It goes on all the time. It goes on all the time. And there's nothing that is unbecoming of a judge who's elected to an office to say, I'm entitled to access to the courthouse. You can't just shut me off from access to the courthouse. To say, I'm picking a different case management system, which, by the way, for probate court, very different from superior courts. You got a superior court clerk, but the clerks for probate court, they serve as both the clerk and the judge. She had every right to pick that. She had every right to ask for that. And if she wasn't polite enough, or if she didn't play well with others, that's fine. We'll take that criticism. Maybe she needs to be told to be nicer, to try to work more cooperative.
You told the IT guy that you were going to sue him, and you copied other judges and professionals. That's not just being mean.
But it's not a violation of the Georgia Code of Judicial Conduct. And then we have the Homeowners Association meeting, for which there is a video. And I do want to flag for you that there are several things that have been alleged that are not what was said there.
Thank you for the $5. Hopefully this is the last question. You said that like two super chats ago. Why would anyone want to get married at their job? Sounds weird to me. Well, she wasn't holding her own wedding, Deacon. She was there to conduct the wedding.
And you will have testimony from someone who was there standing beside her. But what happened here is that in a prior lawsuit, the person who had been removed as the homeowners board chair starts baiting her and going after her. She had every right to be there. She had every right to speak up about her property that she owns and how the homeowners association was being run. And the idea that this person who doesn't like Judge Peterson because they were adversaries in a civil lawsuit is going to be brought forth and put on the witness stand, and she's going to be the arbiter of whether Judge Peterson was engaged in conduct unbecoming a judge. She didn't lose confidence in the judiciary because of anything Judge Peterson said or did there. She didn't like Judge Peterson to start out with, and she saw a chance to file a.
Of course. It's all spite driven.
I've probably not covered everything. I have tried to be briefer, maybe unsuccessfully, but I have tried. And I want to finish just with this. I'm not saying Judge Peterson did everything perfect. There are no perfect judges. And I'm not saying that there are things that she did, even if she did them right, that she couldn't have done them better as she went along. But I've told you about how these people and this hearing panel started filing charges with her before she even had a chance to darken the door of the probate court. How they filed charges against her for having the temerity to ask a question about something that was important to her. So there's no question, there's no love lost between the hearing panel and between Judge Peterson.
Being the investigative.
Investigative, I'm sorry, I withdraw that. Move to strike, Your Honor, between the investigative panel and Judge Peterson. No question about that. But it's not the kind of thing that, again, Ipsy Dixit, the people that don't like you, whether they happen to be members of the investigative panel of the JQC, or whether they happen to be people who voted for somebody else in the probate race, or whether they be folks that just didn't like Judge Peterson getting elected, get to say, you overturn the will of the Douglas County voters. Thank you. Thank you for your patience.
All right. Now we're going to go. Yeah.
Back to contact my supervisor.
Oh. All right. So now we're going to go to. This is her. She's testifying again. Testifying. Wait, is this the right one? I thought this was the right one. No. Aha, here we go. This is her.
Formal request won't come until directed verdict time, but I assume you have no objection either to the form or more particularly the substance of what Ms. Veal is trying to do. Okay.
Happy to have that as well.
You're open to that. Good to know. Ms. Veal, my review of an outline that the panel prepared is that those dismissals don't remove from our consideration any of the, I'm gonna call them episodes or incidents. They are subsets of it, different allegations of, I guess it would be different rules that were allegedly violated. That's been removed from our consideration, but not an entire.
Guys, that's not me. It's the live stream. It's not me. I promise.
For example,
it's not me.
House with the bride and groom after hours. In other words, on the weekend. That's an episode that we're considering. That's still with us, but there may be some of the allegations or alleged JQC rule violate, not JQC, Code of Judicial Conduct rule violations. Those are what you're removing. Okay. Great.
Just a quick sort of parliamentary inquiry. So we started with 50. My understanding is 20 have now been dismissed and we've got 30 left. Is that?
Okay, I didn't do a count. I know there was an initial wave. Yeah. Okay, so it's probably like 20.8 if it's that technical, but we had an initial wave before we started. And then this second wave and we've kept track. I just didn't tote them up. I trust you that it's 20.
Okay, thank you.
Sure. Ms. Veal, tell us your forecast for at least maybe through lunch. You've got witnesses that'll get us through 12:30 stop time.
Yes.
Okay. One last procedural matter, and let's see if my colleagues have anything. There had been some discussion through email communications about having one of your witnesses appear virtually. That's not happening now.
I'm sorry, Your Honor, that is not happening. That witness's travel plans changed, so she's here in person.
Okay, so every witness you plan to call will be a live witness,
Yes.
meaning appearing here in court.
Yes.
Okay. Anything else from the director before we resume receiving evidence?
No.
Mr. Tate, anything you want to get on the record?
No, John.
Okay. Anything, Mr. Lopez?
Just turn on the mics so that people.
Yeah, make sure your mics are on with the little green light. And we'll take it from there. Anything else?
Please fix it.
Good. Should call
The
your
judges need to fix theirs. Oh, she calls her PJ. Okay, so this is the woman who was held in contempt by Judge Peterson for trying to amend her marriage certificate.
Your Honor, do you want me to administer the oath or?
If you don't mind swearing the witness in? Thank you. Could you stand for the oath? Thank you.
Yes.
Thank you. Sorry, we didn't warn you to be doing that. We're ready.
Good morning. Can you please introduce yourself and spell both your first and your last name? I'm Prashabadi Skelton.
We need to get that microphone. There we go.
Okay, I'm Prashabadi Skelton. First name is Prachhabordee. Last name Skelton is Kelton. Skelton.
And if you could, please, I know, can you move your chair a little bit, move the microphone right in front of you? Okay. The court reporter, Ms. Skelton, has got to take down everything you say. Okay, so I want to make sure we can hear you. Can you tell us, Ms. Skelton, where were you born?
I was born in Thailand.
Thailand? Okay, and when was that?
In 1991 in Bangkok.
1991. Okay. At some point, did you come to the United States?
Yes.
And what was that for?
To study in high school.
Okay. Where did you enroll in high school?
I went to junior high school in Texas, and I went to senior high school in Florida.
Okay. And given that you were born in Thailand, how did you go about enrolling in high school in Texas and Florida?
My parents was the one who handled everything.
Okay. And when you say your parents, who are you referring to?
My mom and my uncle.
Your mom
And my uncle.
and your uncle. Okay. Can you tell us your mom's name?
Thanatwan Junongyai. TANAWAN. And the last name is Junongyai is JUNNONGYAI.
And when you use the term your mom, is that your biological mother?
Yes, my biological mother. Yes.
Okay. And you said your mom, and then you mentioned your uncle. Can you explain to us why, when you use the term parents, that encompasses your uncle?
Because they're the one who looked after me since before I was born until I got married. So.
Is this your biological uncle?
Yes. My mom older brother.
Okay. Can you tell us his name and spell it, please?
Supot is SUPOT. Last name is Junongyai the same way. JUNNONGYAI.
Was your biological father involved in your life at all?
No.
Okay. Do you know him?
No.
When you came to the United States for high school, you said your parents coordinated everything to get you here for high school. Did you stay in the United States and complete high school?
Yes. I completed high school here, but I go back home every year.
Okay. And what state did you complete high school in?
Florida.
Okay.
Hey, what's up, Unclean Hands?
Every year.
Yes.
After you graduated high school, did you make a decision about where you were going to live?
Yes, I was going to Jacksonville State University and earn my degree there.
Okay. And where is that university located?
It's in Jacksonville, Alabama.
Okay. Who enrolled you in the university?
It was me who applied, and then also my teachers back then, and then my godparents. So like the way I say godparents is the one who I stayed with when I was in Florida.
Okay.
They helped me through.
Okay. And at the time that you applied to the university, what was your status here in the United States?
I was on their student visa.
Okay.
And
Pretty standard.
Part of that process, applying to the university, did you have to provide information related to your birth, i.e., did you have to provide a copy of your birth certificate?
To be honest, I don't recall. I think you have to when you apply to college. I might have.
Okay. Well, let me ask you this. At that time, when you enrolled at the university, did you possess a copy of your birth certificate?
Yes, because I come back from Thailand back in 2010. Yes.
Okay. And what was the copy of your birth certificate that you had in your possession at that time?
It was in English version because I never have or I never seen the original one, the one that my mom have.
Okay. And so where was
Okay.
the original?
With my mom in Thailand.
Okay. And so the one you had, you said it was an English version. And where did you get that copy?
My mom had got it from like a translated company place. So that's how she got. And then just give it to me just to have it in hand.
And is that copy the one that you've referenced? Is that the one that you would use anytime you needed to use a copy of your birth certificate or apply to anything or provide documentation?
Yes.
Did you ever have a problem or encounter a problem in using that copy of your birth certificate?
No.
Okay, so
Your Honor, may I-
so obviously her original birth certificate is going to be in her native language. And I also imagine that getting the birth certificate translated to English probably makes whatever copy she has not like going to be like necessarily like certified. That's possible. I mean, there probably are ways to do that. But yeah, that's but what are you gonna do? Like if you hand a birth certificate to somebody in the States and it's in Thai, there's not going to be a whole lot of people that's going to be able to understand that. Yeah.
Yes, ma'am.
So I'm going to show you the records, exhibits 61 and 62, and we stipulated to these exhibits.
I imagine there are. I just don't know if one was used. Griggsy.
Yes, this one. Yeah, it's put up.
Okay, can you tell me what 61 is?
That's the one in English version, the
English-
translated one.
Okay, and so 61 is not on the reference that we carry around. Okay. And what is 62? What did you recognize that to be?
That was just a copy of the original one in Thai version.
All right, and Ms. Skelton, can you see up on that screen next to you? Are you able to see this document? I'm showing you the records exhibit 61 that you just looked at.
Yes.
You able to see that? Okay, yeah, I'm gonna have some questions for you about that. In I'm sorry, let me back up. Who is Montavious Skelton?
My husband
Okay, and where did you meet your husband?
in college.
At some point, did the two of you decide to get married?
Yes. So we met back in 2012. And we got married in 2016. I was supposed to, I graduated, supposed to leave and go back to Thailand, but we got engaged on my graduation day, which is on
Aww.
Friday. And then we decided to get married just like 4 or 5 days later on Tuesday.
Damn. Nice.
The reason we do everything so quick because my mom and my uncle was in the state at the time.
Because your mom.
Oh, they were in state
Was here.
for graduation.
Yes.
You wanted them to be able to attend your wedding.
Yes.
Yes.
And so, you said you guys got engaged on a Friday, and then a few days later, you said you decided to get married. Where did you go to apply for your marriage license?
In Douglasville. It's not so far from Jacksonville where we live. So that's why, and we were planning to move here to Georgia.
Right, so you went to Douglasville, and are you the one that filled out the application for a marriage license in Douglasville?
With my husband, yes.
Okay. So Ms. Skelton, the hearing panel has already heard some testimony in reference to this matter. But I want to ask you, when you filled out the application for your marriage license, when it called for your father, it had a box and asked you for that name. What name did you provide there?
I put my uncle down, Supojunongye.
Okay, and can you tell the hearing panel why you did that?
Everything happened so fast. And my uncle was there. And he was the only person he could think of at a time.
Oh no. He's gonna start crying. So
When you filled out that application and provided your uncle's name instead of your biological father's name, Did you think anything of that decision at the time? Like, did you think that there was anything wrong with that decision, or?
I just don't have a memories of my dad. I don't know who he is.
So what she's saying is that because she grew up with her uncle, and basically her uncle was her father for her whole life, on the marriage certificate, she, on the name of the father, she put her uncle's name, because she has no memory of her biological father.
I'm sorry.
It's okay. And Ms. Skelton, if you need to take a break, you should let us know. I've got a question, if it's okay. At the time, did you even know your biological father's name?
No.
Could you have put it on the form
At the
correctly?
time. No, I wasn't thinking about him at all. I had asked my mom, but I just never get an answer.
Ms. Skelton, had you provided or given your uncle's name previously when you had filled out forms, or when you were asked who your father was?
Yes, I think I have.
And what is your wedding anniversary date?
It was May 3rd, 2016.
Okay, and that's the day you guys got married? Okay, where'd you get married?
That at the Douglas courthouse, Douglasville courthouse.
At some point after May 3rd of 2016, did you make the decision to go back and amend your marriage application?
I actually forgot about it.
Okay.
Because everything happened so fast, and we just starting everything. Everything was just so new. And I 2 months later I was pregnant, and we have moved maybe 2-3 times, and life just go on. So I completely forgot about it.
Was there something that happened in your life that reminded you of it?
It's just one day that after we moved, and I had things that I have to look at, and one day I just seen this application, and I was like,
Well, the problem, Aaron, is a lie implies intent. Did she knowingly and willfully put her uncle's name on the marriage certificate, knowing that she wasn't her biological father? You could say yes, but in her mind, her uncle was her father. So I would say that because she was there, because at the times when she put pen to paper, she's going to, if she puts C's father, she's going to put her uncle's name, because that's what she's saying in her head. So based on that, and based on her testimony so far, it seems to me like it was an honest mistake and not a willfully false statement with the intent to deceive or defraud anyone.
I was like, something is just not right, because it has
Or was done with any maliciousness.
the birth certificate, even though I don't know who he is. I just have to make the right thing. I just have to correct it and go back and make sure it's matched the birth certificate. That's all I know. And nobody knew. My husband didn't even know about it. Nobody knew, actually.
When you say your husband didn't even know about it, what are you saying he didn't know about?
I was going to like what happened to that application, because I don't think he remember. And also going back to the court in Douglasville, he didn't even know. I just go, I just show up at court.
Okay. Was there something was that at some time in 2021 that you came across it and you decided to go and change it?
Yeah. So it was just a time, and I had time. I was like, okay, I'm gonna go today, because I have time to go. So
Was there something at that time going on with your mother that played into or was part of your decision to go and try to have your application changed?
at the time I was applying a green card for my mom, but thought about it, it's not about her, it's about me who need to correct my information.
Right.
It's not about her.
Because the name that you sought to correct was not your mother's name.
Mm-hmm.
And were your mother
Right.
and your father married?
No,
Were they ever married?
I don't think so.
So I'm going to direct your attention to August 2nd of 2021. Is that the date that you would have filed the petition to amend your marriage record?
I think so.
Does that sound
It's
right?
around August.
Okay. I'm going to show you director's exhibit number 33 and just look up there on the screen for me, okay? Do you recognize director's 33?
Yes.
Okay, and what is that?
Yes, that was, I filed to go get, my father name changed to my biological father name. So,
Right, and this is what you filed, so this is what you filled out at the court the day that you went there?
yes,
Okay. And right here where you have father's name should be this name, Wasu.
I think I saw a copy of what they're saying. It's nothing really significant, but it's just made her like wanting to amend her thing. The problem that what I'm thinking is if we're gonna go by Judge Peterson's standard in this, literally anybody who files a petition to amend their marriage certificate can be jailed for contempt. Anybody who does it, anybody who tries to amend an official document can be hooked up for contempt. So why would they even bother doing it?
That's your biological father?
yes,
Okay, and then below that, Supat, that is your uncle's name that you provided on the original application?
yes.
Okay. When you went to file that at the probate court in Douglasville, did you have any assistance?
No,
Okay,
I was by myself.
okay, so you didn't have an attorney there assisting you?
No.
Okay. After you filed that petition, what was the next thing that you heard from or out of the court?
Was the letter that I received to be at a court, August 24th. Oh, wait, yeah, August 24th.
All right, Ms. Felton, I'm going to show you directors 34. You said you received a letter from the court to be there on August 24th.
I did see this letter.
34, the letter that you were referencing in your testimony?
Yes.
Okay. When you received this letter, what was your understanding about what you were going to court for?
I just thought I had to show up. Got to be there at before 10 a.m.
Okay. What did you believe you were showing up for?
To have my father name changed to my father name.
Okay. Did you receive any additional correspondence or directions from the court in reference to this hearing on August 24th of 2021?
I don't think so.
Okay. Did you consult with or take an attorney with you to this hearing?
No.
Did you feel like you had a reason to do that?
No, I just didn't know anything, have no knowledge of anything.
Okay. Did you go to the hearing alone?
My husband was there with me.
Okay. And at that time, did you all have a child?
Yes.
Okay. And how old was your child at that time?
She was 3, 4, 3, I think 3.
Okay. She was not with you all on that day?
No, she wasn't. She was at a daycare.
Okay. Did you go to this hearing with any idea that you may be going to jail?
No.
Did you take any documents with you to the hearing?
Yes, I took their birth certificate, the one that you was pointing at earlier.
Did you take any additional documents or was that all?
That was all.
Okay. So I'm back to 61 on the screen. Is that the document that you took with you to the hearing?
Yes.
Okay. When you got to court, and the hearing began, what do you remember happening?
I was there. Honestly, I don't remember anything. All I know was there to, get the father name changed.
Remember, when the hearing started, do you remember, was there a judge there?
Yes.
Okay. And what was the judge doing during the hearing?
Was going through the paperwork, the document that I have found, and I have handed this birth certificate to her.
Okay, so at the time of the hearing, this birth certificate, that's Director's Exhibit 61, had you submitted that to the court previously?
I don't think so.
Okay, but you recall that during the hearing, you presented that document to the court?
Yes.
Okay. What happened when you presented Director 61 to the court?
So I was told that it was a false document, and
Hold on, let me stop there. You said you were told that it was what?
it was a false document, because at the bottom, which I never pay attention to, I can't read that. And she had pointed out, which is true, that it
Not a certified copy.
I'm sorry.
It probably says not a certified copy. Or not to be used as a certified copy.
I just
Very faint here, but you see that it says a certified translation not recommended as a legal document?
Mhm.
Okay.
Ah, there.
And you said that the court pointed out that it was a false document?
Mhm.
Did you?
Ms. Skelton, I'm sorry to interrupt, but when you're answering, we need you to say yes or no, or maybe, whatever the word is, but not, because the court reporter never knows if that's a yes or a no.
Yes.
Okay, thank you.
Okay, so let me ask that again. You said the court had pointed out to you that this was a false document.
Yes,
Okay, did you understand that this was a false document?
that was my first time understanding it. I've been holding it for 11 years, and I didn't even know. So that was my first time understanding it.
Okay. Do you remember what you said to the court in response?
All I remember, I don't think I have said anything else. It was just at the end.
Did you have any other documentation to provide to the court at that time?
No,
You said you remember saying something at the end. What do you remember saying at the end?
I think the court gave me a chance to say something before it was taken. I think I was mentioned about my uncle. That's it.
Can you pan out or demagnify a little bit? Perfect, thank you. Ms. Skelton, just so I'm clear, I think you've already talked about this. The person listed as father here in the birth certificate, Mr. Summerjai, that is your biological father. That's not your uncle. Is that correct?
Yes.
Okay. The name that you had put on the wedding paperwork, the marriage application, et cetera, was your uncle's name, because that who in your childhood and beyond had sort of served as the father figure.
Yes.
Got it. Okay. So the birth certificate is, I'm gonna call it accurate, whether it's a legal document or not, we don't need to work through, but it's accurate. Mr. Summerjai is your biological father.
Yes, sir.
Thank you.
And Your Honor, I know that there were portions of these that were not in the original binders. We made copies of those subsequent exhibits.
Well, thank you.
Ms. Skelton, in response to my last question, you said that when the court gave you an opportunity to say something, you said something about your uncle.
Yes.
Okay. Did the court give you any directions about what you needed to do after that hearing?
Yes.
Okay, and what were those directions?
I needed to get a new translation version in English. That's all I remember. Sorry.
It's okay.
Ma'am, can I ask you a question? At any point in the hearing, did the judge give you an opportunity to hire a lawyer? Did she tell you you had the right to a lawyer
I think she might have at the beginning.
at the beginning? Of
Well,
the
she asked me if I have a lawyer with me, but I didn't.
Did she say that you could go get one if you needed one? Or she just asked if one was with you?
She just asked if one was with me.
Ms. Skelton, did you, during the course of the hearing, you said you
They can think of the $20. Okay, the only reason I have beef with the former judge is these sounds like exploitation charges. Now that is just in my opinion, but it sounds like the former judge did exploit a person in a very vulnerable position. Again, I'm saving the speculation for after we're done.
you just remember speaking at the end. At any time, did you raise your voice? Did you yell? Did you do anything like that? How were you feeling during the course of the hearing?
I didn't yell or anything. I just had to respect the court at a time. That's nothing I can do at a time. So, but to listen.
And what happened at the conclusion of the hearing?
So I was taken to jail. My husband was I think he went to get cash to, I don't recall. So basically what happened was I think I either have to choose between if I want to be there for a couple weeks or I choose to pay the fine of 500 and stay in jail for 48 hours. So my husband, well, after I left, he went and get cash and then, provide that fee to the court.
Your husband went and immediately got $500 in cash.
Mhm.
And ultimately, how long were you incarcerated?
Not that long. I don't think so.
The 48 hours.
Oh yeah, it was 48 hours.
Had you ever been jailed before?
No, sir.
Had you prepared your work for the fact that you might be in jail?
No.
Had you all made childcare arrangements?
No.
After you got out of jail, what steps did you take in order to get the translated copy of your birth certificate that Judge Peterson wanted?
I just went online and looked for the certified translation company and just get it done, as fast as I can and brought it back to the courthouse.
What did you provide that translation company so that they could do the translation?
I actually asked my mom, called my mom and asked her to send me an original birth certificate. And she sent it to me and I used that to provide it to the translation company.
Right, and I'm showing you Director 62. When you say that you asked your mom to send you a copy of your birth certificate, is Director 62, does that look like the copy that your mother sent you?
Yes. She sent me the original one.
Okay, so this is a copy of that original.
Yes.
Okay. So you give this to the translation company, and then I'm showing you Directors 63. Do you recognize that document?
Yes.
All right, and here's the second page. What's Director 63?
Yes.
What is this document?
Is their translate version, the new one that I received from the company.
Right, and is this what you ultimately provided to the court?
Yes.
So she then tried to get an actual certified English translation.
What was your understanding about what would happen if you did not get another translated copy of your birth certificate to the court?
Probably be in another trouble.
Okay.
Probably.
Another in trouble. What do you mean by that?
Don't know if I'm going to go back to jail or not.
I could just have 1 minute. That's all I have.
Kate, do you have questions for Ms. Skelton?
Just a few.
Okay.
Morning, Ms. Skelton. How are you?
I'm good. How are you?
I'm Lester Tate and I represent Judge Peterson.
This is Cross.
If I understand correctly, you put your uncle's name on your marriage certificate, listing him as your biological father, correct?
I put my uncle name down on the applications. When it say father.
Okay. And are you aware that at the bottom of that application, there's something that says you certify that's the truth, you swear to it under oath?
Yes,
Okay. And at the time that you put your uncle's name down as your father, you already had that birth certificate, the translation that's number 61, correct?
yes.
Can you pull that up for me? Now, I understood, and I tried to make some notes, but I understood earlier when you testified today that you said you were in a hurry and you didn't really even know your father's name. Is that correct?
Correct.
Okay. So if we could blow that up there, is this is 61 that you've had since Exhibit 61 that you've had since 2010, correct?
Yes,
And it's the one that you used when you applied to the university that Ms. Veal asked you about, correct?
my
Okay. And so if we look on down here in section 3 there, you see your father's first name, Wasu. Did I pronounce that correctly?
I think so.
Okay. Well, your father's name, that's your father's name, not your uncle's name, correct?
Biological father.
So I just want to make sure I understand. You've had this birth certificate since 2010. And then today you testified that you didn't even know your father's name, but it's on this birth certificate, isn't it?
I don't read his name.
Beg your pardon?
I don't read his name. I don't pay attention to what on there. That's what happening.
You don't read his name?
Yeah.
What do you mean by that? I'm not sure.
I just didn't pay attention to it. Like,
In other words, she only cares about when she's looking at a birth certificate, she's looking at her mom's name and whatever relevant information is there. But the fact that she knows nothing about her father, she's not going to bother remembering his name on a regular basis like she would know her uncle's name. I think that's what she's getting at. She's like, why would I bother remembering my dad's name when he's, for all intents and purposes, he was never my dad.
I don't know if that's the right name. I don't know if I pronounce it correctly. I just never pay attention. I just have it in hand. That's all.
Uh-huh. Well, can you understand why, if you have this birth certificate that has his name on it, it's been translated into English, and yet you put your uncle's name down and then you want to go and change it back, why somebody might think that's not being forthright?
It was me.
It was you.
Mhm.
You didn't tell the truth about it the first time when you put the application down, correct?
He's just never been in my life. And at a time, how my brain think is the father I have is my uncle,
Mhm.
who's been there mentally, financially.
Mhm.
He used everything on me. He raised me. So him just never important or never in my blood or in my brain. So I completely didn't think about him at all.
Absolutely understand that. Not trying to beat you up here about this, but you keep sort of pointing your brain. Nobody else really knows what's in your brain, correct?
What she's saying is what I've been trying to say, is that whenever she sees any sort of document that says father, her brain is going to immediately go to her uncle as the first place to go to.
Mhm.
Only you know that,
Yes, sir.
correct?
Yes, sir.
And can you understand how somebody that's not in your brain, but is looking at it from the outside would say, we were misled.
Yes, sir.
That's not a stretch to say that, is it?
What is it again?
I withdraw the question. Now, you also testified here today, if I wrote it down correctly, that after you did this, you felt like you had to go back and make it right
Yeah, to match it.
Okay.
to match. And you say you started thinking about that when, right after you did it?
No, because I have forgot about it.
Mm-hmm.
Not just right after. Completely forgot about it, to be honest with you.
And so did you just decide one day, okay, it's time for me to go down there and make this right?
It's not like that. I just filed the paperwork. I had misplaced stuff. One day, just putting things together means clean out my room, have my document together, and I see it, and I was like, yeah, I just have to go back and make it match the birth certificate.
Okay, so you were cleaning out your room, looking at your documents, and you see the marriage certificate.
The application certificate.
And it was sort of then and there that you decide, I need to go get this corrected. Is that
Yeah,
right?
Why don't you say I should go get it fixed?
Okay. Well, now, I understand that's what you're telling us here today. When you went to the probate court, did you tell them that your mother was trying to get admitted to the United States?
I don't recall.
Okay. But it is true that your mother was trying to get admitted to the United States,
Yeah, but
correct?
it's not about her, it's about me.
Okay. And so are you saying, no, I didn't tell Judge Peterson or anybody down at the probate court?
I don't recall.
You just don't recall one way or another.
Mhm.
Fair enough. Fair enough. And so did you also tell somebody down at the probate court that you and your father had not been on good terms, but that since then you had sort of made amends with your father?
So at the time, I don't remember what I say, but it was not, I didn't know what to tell or say. Nobody tell me anything. I was by myself. It was really sensitive to talk about. It's really sensitive to talk about him or how I grew up. So
Well, I don't want to pry, but I need to ask you about what you said. You said something to the effect that you and your father weren't on good terms and that you had since made amends with him or gotten along better.
I might not, the way I
Yeah.
say that to
Yeah, I don't know where he's kind of going at with this.
her, it means how is I'm in a good term? I don't even know, like,
Uh-huh.
don't know at all.
Had your relationship with your father improved since you put your uncle's name on the?
No, I don't know him. I don't know where he at. I don't know where he at.
Okay, but you may have said that you and your father were getting along better as a reason for changing this when you went down there,
My
true?
uncle, yes, my uncle.
Okay, so was your mother
Wait.
trying to get admitted to the United States during this time?
I'm the only child, and I need to see my parents.
Mhm.
And I have a kid. So I wanted my mom, only one, and my uncle to be able to see my kid. And it's easier to like come in. So like, why don't I just, have her come and then apply her green card? Because I had lost many years not spending time in person, touching, knowing. So that's why I have her
So,
applying.
I hear your.
So I imagine at that point, she probably already got her citizenship.
Explanation, but I didn't hear a yes or a no there. Yeah, so the answer is yes, you did.
Can you repeat my question?
Yeah, is
again?
the answer yes, that you were trying to get or wanted to be able to get your mother admitted to the United States, and if that was one of the reasons you were going to the probate court to get this
No,
changed?
that's not the reason.
Did you tell them that at the probate?
Answer.
It's a different question.
Well, you can ask it one more time, but then let's move beyond the mom situation. I think you have asked and she's answered, but we'll close it out with this question.
Did you tell the folks at the probate court that one of your reasons for trying to get this corrected was to be able to get your mother in the United States?
I don't think so.
You don't think
I
so?
don't remember.
Okay. Now, just 1 second.
Sure.
Like I don't. is he going down the angle that her, like she had other motivations to change, to amend the birth certificate other than to correct what would normally be an honest mistake? What would be considered to be an honest mistake?
Ms. Skelton, I just want to clear one thing up because I want to make sure the hearing panel understands. Mr. Tate was asking you some questions about what you may or may not have said to individuals that worked at the probate court. So I want to be clear, have you ever had a relationship with your biological father?
No, never. Don't know what he looked like. No.
Okay.
Even I had asked my mom, I think I asked her 1 or twice, but I respect her. I don't know what she's been through. So I just never again or I don't know who he is.
Okay, so if you had referenced a relationship with a father to a member of the probate court, would that have been about your biological uncle, do you think?
Action leading.
You can rephrase it.
It's a bit of a leading question there.
Did you make any statements or do you recall making any statements to any of the individuals at the probate court about your relationship with your uncle?
No.
Okay. Had your relationship with your uncle changed around the time that you went to apply for your marriage application?
No, it's always been the same.
Okay, and when you say the same, that is?
Like he was there for me.
Objection relevance.
He was there for me.
And told people probate court about that. I'm not sure what the relevance is.
Okay. The relevance.
Judge, I can move on.
Okay.
Have you ever spoken to or had a conversation with your biological father?
You mean like with him?
Yes.
No.
Okay, that's all I have.
All right, any recross? Ms. Skelton, thank you much for coming. Appreciate it.
Thank you. Thank you, everybody.
Did you have any questions? I didn't mean to rush. Oh, okay. Next witness?
Okay, so I think there is, she does try to put on her names, well, not her, oh my God, what the hell did I just say? Judge Peterson does testify as to why she held her in contempt. I need to find that, but I'm going to save that for another stream. It's been about 2.5 hours, so I kind of want to cut it here. So I'm gonna look for that in the record so we can see what she says as to why she did what she did. So Aaron, I think other people I think other people had it right that he was trying to establish that she had an ulterior motive or a deceptive motivation for changing the name on the certificate to either to justify what Judge Peterson did, to justify the contempt or the severity of the contempt even. So this is, I'm gonna preface this very much right now. This is speculation based off of only a little bit of evidence from her social media accounts. But it's speculated that the underlying reason why she went after her this bad, 20 days, I was incorrect, not 30 days, it was 20 days for contempt and or a $500 fine, was because there's things suggested in her social media account that she's not a big fan of miscegenation, race mixing. And because JP married a black man who was in attendance at the hearing, there's suggested that that's what set her off. I need to do a little bit more research to kind of confirm that, but that's an implication. Actual Justice Warrior covered her, and he says it like definitively. I'm nowhere near as confident as he is, based on what he says. but that's a suggestion based off of her social media accounts. Anyway, I'm gonna end it here. Give you guys a chill, and I promise I'm going to look at. I actually do want to. I do want to go through her testimony, for sure. But I want to absolutely kind of go through, her explanation for why she did what she did with this woman. But I want to appreciate you guys coming in, and chilling with me, talking to me. I appreciate all the super chats today. Thank you guys as always. I hope that you guys have a good rest of your evening. Tomorrow. Okay, so I think tomorrow I suggested that I posted this in Discord, guys. And what would you say if we crashed a Telegram video conference hearing on the right to travel? I got an invite where it's going to be a course on right to travel. It's set for tomorrow at 7 o'clock. I'm thinking, why don't we drop in and we can have a little bit of fun. So that's supposed to be set for 7 o'clock. So let's see what happens. All right. Take care, guys. Have a good night. 7 o'clock p.m. 7 o'clock p.m. Who's teaching it? It's I don't even know which Telegram group is teaching it, to be honest. I think the Telegram group is literally called Right to Travel. Yeah. Hold on. I'm gonna bring it up right here. Right to Travel chat. That's literally the name of the Telegram group. So 7 p.m. Eastern. All right. Thanks, guys. Have a good night. Take care and see you tomorrow. Bye-bye. Bye. Bye.